thousand of how the RJA is coming along. So I guess to start, we could unveil our website, and then we'll be able to get to this wonderful panel, and then I'll introduce our wonderful speakers.
Right on. That's my cue, right? All right, let's do this. What's up, everybody? My name is Andrew. I'm gonna be introducing this website to everybody here. Let me screen share this thing. Everybody can see that. All right, awesome, awesome. Um, welcome to the rjaction.org website. This will be really brief. Just going to kind of give a quick overview of kind of the components of the site, and kind of how it can be useful, and really how we're going to continue to archive these stories of folks fighting for the Racial Justice Act and for loved ones that it can impact. So First off, we're using this as an active space to record and document all these stories. So whether that's situations that we see in court, people that we're supporting, and it's not just here in San Jose in a debug, but this is something that parts of defense hubs around the state have been contributing to. It's something that we want to continue to encourage people to share their stories, and the more that we lift these up, the more that we post about and we share them, the more that we can learn and how this can be an effective tool to support people. So these are all the current ones that we have posted, and this is something that we're actively posting, and putting up new stories as frequently as we can. Um, Once you scroll down here, we give a little bit of background on the Racial Justice Act, and then also going through the types of claims. I think from an organizing perspective, for parts of defense hubs and folks that are trying to support families, it could be helpful to understand, trying to simplify it to be able to folks be able to understand, so they can see where it applies and where it doesn't. Um, and then getting into here, we have a section that we call cases to claims, but essentially we give examples, and these aren't made up. These are things that we've seen. These are things that folks have seen in court. We keep it anonymous in terms of the loved one who's facing the case, or all that kind of stuff. But we want to give some background, and so we talk about the background of what the situation was of the incident, or of what the allegations are, maybe what the charges are, the conduct of the DA or the police officer, whoever it may be. And then we talk about what the claim is. And then as we follow it, if there is an outcome that's available at that time, or however it looks like, we'll share that outcome too. So this is an example right here. This one is of a DA expert who made a really racist remark in terms of associating domestic violence with our Latino community. And so we gave that background. We talked about what the claim was when the RJA claim was filed, and then go through that process. So we've been compiling these. Folks can read through this when they want to visit the website, and take a look at them. Like I said again before, these are things that we ourselves, or folks that do parts of defense have seen and witnessed, and we're in court for that. And so we've kind of watched all this unfold. We think it's important to share this, and to lift this up, so it's really transparent. Daddy, I was talking you. Yes, thank you. My colleague right here is asking to change the channel on the TV. But and then lastly, the last section of it uh is essentially how to find a parts of defense hub in support of your Racial Justice Act claim. So if folks are looking for support, sometimes I think there's a lot of questions, especially for families and folks who have loved ones, whether facing a case pre-trial or facing a case, or is inside right now, post-conviction. A lot of those questions of, does the RJA apply? How does it apply? So we don't want to just give information and just not be there to be able to support people and help people. So with that being said, the purpose of this is to also be able to connect people with folks that can help, and help talk that through. So yes, it gives a little bit of background. And then this link right here also sends you to the Parts of Defense website where you can find hubs around the state of California, and find contact information and reach out if you do want to talk with them, or go to a meeting and have that discussion. Um, yeah, so I think that that's it on my end. The last thing I wanted to say, at the top of the website, we have a subscription. So if folks want to subscribe, we have like a newsletter, like a blog newsletter. So every time we post a new story, we share that out with everybody that subscribe. So feel free, you can go to the website rjaction.org and enter your email. Or also too, if you guys want to, you guys can throw it in the chat right now. And we're down to gather emails and add you guys to the list as well, from the chat. But yeah, I think that's it for now. Um, am I missing anything? Zach, or others?
No, I think you and your colleague did a great job, Andrew.
I appreciate it. I appreciate the moral support for her.
Cool. Thanks, Andrew, for showing that off. And I just want to reiterate what Andrew said, which is this is a living website and we're not guarding it. We encourage people to reach out in the chat. And then, if you want to contribute a story, I know many people here have had some involvement, whether as an attorney, but also, more importantly for this website's purposes as a family or as a person wanting to file an RJA claim. So I just want to recognize that. But yeah, thanks for Andrew. And thanks for all the hard work on the website. But it was informed by, like Andrew said, going to court, and creating relationships, with attorneys who are kind of willing to push this ball forward in light of what has been a lot of pushback from DAs and judges. So now I think we can move to the part I'm excited about, which is a conversation with our panelists who come from a range of different experiences, but all have been kind of in this RJA swamp for the last few years, trying to figure out how to push, like I said, how to push the ball forward. First, I think we can start with the person who has that 10,000-foot view, um, which is Brooke, who is on our panel, Brooke McCarthy. And she's the non-capital racial justice act attorney with the Office of State Public Defender. The Office of State Public Defender, for people who know, they're great. They host trainings, and they have, four attorneys have this wealth of knowledge and case law that the attorneys can pull from, so that it pretty much democratizes the system so that we don't have our RJ, geniuses like Brett and Brooke kind of hogging all the shine, but it makes sure that attorneys who might be in other divisions working on misdemeanors have the ability, to actually push these claims forward. And we know that the system is rife with racial bias, so it's really important that knowledge is spread. And Brooke is amazing in doing that. She also, anything about data, she somehow also knows about that as well. So I want to thank Brooke for coming, and we'll be hearing, a lot of that 10,000-foot view, but then also, what's coming and what are some of the hangups from her perspective. Next, I'm going to introduce, one of my favorite people in our participatory defense network. She's from our southernmost California hub. That's Layla Aziz, who's a longtime organizer, directly impacted, but also just the the loudest but the most critical voice when it comes to these types of issues. And we always appreciate Layla because she's always on the cutting edge. She's always in court, and she's always coming up with new ways to, I think, dramatize the real issues of racial injustice in the system as it impacts, especially Black folks in San Diego. And so I'll have Layla talk a little bit about, this tribunal that they did that I think is in the spirit of the RJA, and kind of reflects what we can do locally in our own places to show what these disparities look like in real time. And that gets to kind of our local landscape here in Santa Clara County, where we're based. And we have Brett Hammond. Um, Brett Hammond's deputy public defender from Santa Clara County, an amazing attorney, who is very, very kind of calm, makes us feel calm outside the courtroom. But once he gets into the courtroom, he's fierce, fierce advocate. And we're really lucky to have Brett. And especially in our relationship with Santa Clara County Public Defender is really key to any of the success that we've had with any of these RJA claims, and really admire Brett and the rest of the team and their willingness to put a lot of time into these RJA motions, one, to help the clients, but also to push this law, forward. And finally, I get to introduce Xavier Spania. He's my colleague. Oftentimes we're in court together, but he gets into the courts a little more than I do, looking at what I think is 95% of the RJ hearings that have happened, whether it's a continuance, whether it's an evidentiary hearing, whatever it is, Xavier's there and he has that perspective. And Xavier also has kind of an interesting perspective as well, similar to Brooke, as he's the one who manages our mail and has kind of an understanding of what people who are incarcerated are asking for, especially when it comes to AB 256 and making these retroactive claims, which is proven really, really tough. And I think just as like a general capstone before we start is I think that the purpose of why we're here is that this RJA is this very, very promising tool. But it also, like I said, it kind of democratizes a little bit since some of us have been opened up to racial bias. And so we want to talk about how, we can create a team with the public defender all the way from the family member to that attorney who's going to represent you in court to make the best RJ motions possible to put forward community experts and to do all those things. So I'm happy to start with our 10,000-foot view from Brooke, if you will. And I'd love to ask, you're very supportive of the implementation of the RJ, especially on these retroactive claims for the people inside. What's been your vantage point over the last couple years about how this AB 256, this retroactive RJ claim, has been rolled out, and kind of the difficulty generally in getting relief or the ease in getting relief?
Yes, happy to talk on that. Just want to say thank you so much for having me. It's always great to be in community with everybody. And I want to start off by saying that it's very slow right now, but I don't want people to lose hope. As we see with a lot of these big reforms, they take a lot of time. And I know that's much easier for me to say as someone on the outside. And not having a loved one who's serving that time, but I just want to say that while some of the initial progress can kind of seem slow or bleak, that actually doesn't tell us much about where everything's going to go. And so we have seen a lot of challenges, and those challenges have to deal with the fact that, as folks know, our public defense system is underfunded and overworked. And so trying to get lawyers on these cases has been very difficult, especially for incarcerated folks. And so that's, I think, the kind of real big push that we've been focusing on in particularly the last year, is trying to make sure we can get lawyers on cases so that folks inside aren't trying to do all of this on their own. And thankfully, we do have actually a recent win, and I'll drop the information in the chat for people to be able to look at it. But a case did recently come out called Macintosh. This is a pro per filing, someone who's incarcerated filed. And the Court of Appeal basically was very clear that you should be looking at, the information someone puts in their petition to decide if they should get a lawyer before you decide anything else. And that's a really big part of what we've been trying to educate the courts on, is that, typically once you're already convicted and your appeals are exhausted, when you file, you basically have to show that you're gonna win before you get a lawyer, usually, in a practical sense. And so the Racial Justice Act made this really big change for retroactive cases, so for folks who are incarcerated, to say, actually, you get a lawyer before you have to show that you're going to win. And it's this much lower threshold. And so Macintosh is the first published opinion on the appointment of counsel about the fact that the court is supposed to look first at just, do you get a lawyer or not, before looking at anything else. And the reason the published part of it matters is then theoretically, all of the trial courts are supposed to follow it. Of course, we expect that won't always happen, but it's what we call binding on the trial courts, meaning they are supposed to follow it. And so I think what we are hoping to see in the next, 6 months are being able to get more lawyers on these cases, for folks who are incarcerated, start building up some of the data and the information, but are really the just educating the courts on the fact that the RJA has these lower standards. It's not your typical habeas petition, has really been our biggest hurdle. And I think McIntosh will be very helpful for that. And then the other big case coming up is Montgomery. That's in front of the California Supreme Court. Again, I'll drop these in the chat for folks. That'll be the first retroactive RJA case fully briefed in the Cal Supreme. And so it'll be a big deal. And that is, do you get RJA disclosures before they decide your petition? And so we have a lot of advocates that are going to be filing what we call amicus briefs. We're also working with some folks with a firm that's going to write on behalf of incarcerated folks about how hard it is to assemble this information inside, the safety concerns that it poses, etc. But to try and give the court a very realistic view of why you need to get a lawyer and why that those disclosures, that evidence needs to come beforehand. So while it's been very slow slog today, we are hopeful that some things are coming down the pipeline.
Thanks, Brooke. Yeah, thanks for flagging McIntosh and especially Montgomery, which I think gives the California Supreme Court a chance to decide what the promise of RJ and whether it's going to be what it actually should be, especially for people who are incarcerated. And I guess that takes me to Layla, since I know that Pillars of the Community, a lot of the folks that you're kind of contemplating using the RJA as a tool for are folks who are incarcerated already. So Layla, I guess, how have you used the RJA as an organizing tool to advocate for the folks that come through your participatory defense hub? And then if you could you talk a little bit about setting up that tribunal and maybe explain your back screen, since I know that weaves in as well.
First, as you know, Zach, that when we're in court, and I'm not primarily in court, I go to court rarely, even though I would love to go every day. We have a team of volunteers you guys trained up. We have a court advocacy organizer you guys support that is in court every single day. So these people are my bosses. They tell me what's going on and what I need to do. And just having community like that and organizing like that has been instrumental in decolonizing the system as much as we can, and also eliminating mass incarceration. So I'm from the era of where we were looking at a lot of young Black men who will never come home through something called felony murder. And some of you guys worked on SB 1437, and how our district attorney and courts were trying to uphold these sentences, particularly for non-killers, and when they were coming in through the court system. And we started looking at the people that we knew, and through Brian Mason's case, a young man who is now home, that the district attorney fought to maintain his LWOP sentence, we saw that it was very racially tipping. It was very racially inequitable. And we also know in San Diego, because of the work we've been doing with you guys, is that relationship we've been able to build with the public defender's office, and watching Sadaf and her team work religiously in the courts and through the procedures and all the nonsense that I hate, that I think is just like, come on, can we get it over with? Can we rule? But these are things that lawyers do. And a lot of times we discount that work in the rules and the different things that happen even before you come in front of a judge. And so how can we help? How can we be an assistance as organizers to what the lawyers are doing? Because we're not lawyers. We don't pretend to be lawyers. And when we go in there, we are those, like you said, that represent those that are most harmed by the system, and also who have never been able to have equality within the system many times. How do we come in and use what we do well and use our strengths to assist the attorneys that are doing this work in the courts? I was reading Tip of the Spear, which is a book about Attica. And in there, during the jail rebellions, because the Attica rebellion wasn't just the Attica rebellion. A lot of times we don't look at the organizing, the campaigning, the movement building, and everything else that goes before these things. They looked at tribunals and community courts within the jails in order to keep safety amongst themselves without the COs, the guards, and different things of that nature. And I started researching these tribunals that I read in Tip of the Spear, and I saw that the Black Panther Party used them for evictions and different things in the community. I saw that in Ireland they used them from the oppressive English government to the Irish people. And I started following these tribunals and researching them. And I said, that's what we need to do as organizers. Let's step outside of the court and let's hold the district attorney accountable and the courts. We went to Court Watch with you guys, Zach. You took us to San Mateo. And I saw a judge with so much information and data basically still denying RJA. And the reasoning and the logic was profoundly null. And I don't understand how that's not what the appellate courts are going to do. So it's almost as if sometimes it's heartbreaking because you can see how Plessy versus Ferguson, how that was law for so long, because some of the people that are interpreting the law, these judges, are doing so in a very biased manner. So we started doing public records requests. We did it for the district attorney. We did it for the courts. We also did a public records request for CDCR, and we started gathering this information. And we saw a lot was missing in the district attorney's data, and period, that a lot of the people that were charged with murder were not, and felony murder, because it was like needle in a haystack of about 500 cases to get down to maybe 40 cases, right? They were not even on the spreadsheet for whatever reason. We found that a lot of these people were white. And so as we started looking at this data and pulling this data and going into the courts, going into the Court of Appeals, getting the transcripts, which you can get for free from the Court of Appeals if they didn't plea and they had an appeal, and really utilizing everything we've been working on for years with free SD and participatory defense, and we started to see stunning results. When we read these cases and we saw 3 young white men rob a Latino man and then throw 45-pound rocks on his head as his brain splattered, and then marvel at the blood, and then say now they get their bolts, and Black and brown people have gang enhancements, and these young men never had them, and bolts to what I know is a white supremacist gang. And none of them were given LWOPs. They all have a chance to be redeemable. We read Harden when the dissenting opinions of Lew and Evans stated basically Black and brown men are looked at as non-redeemable, non-rehabilitative. And a lot of times the lawyers know a dissenting opinion can sometimes flag us that something can come in the future, right? So what can we do to assist? So we utilized this data, and we served the DA in the same way they serve us. We wrote a complaint. We wrote a subpoena. We marched down to the district attorney's office, and we demanded to be seen. The first people that came before we could get off the elevator were the investigators. What are you guys doing here? We're here because we want to serve the DA. Let us talk to Summers, Stefan, or Woodley. So, and the founder of Pillars always says that it astonishes people in the system when you hold them accountable because they think they're doing great work. And I never really realized that until the second head DA came down and said, but I'm on the website for resentencing people. I'm the hero. And because you want to pick and choose and cherry pick who you resentence, and we want a system change. We want a change in a system that has somehow evolved and keeps evolving, and to be discriminatory, to hold on to discrimination and all those founding principles that have screwed us from day one, right? So he said, I'll be there. I don't think he realized what he was committing to. And he sent the former head gangs dep chief, who is now a little bit higher up, to the tribunal. He came. And we blew up these pictures we got from CDCR. So now you have to see these people. These mugshots of Black and white people are all over the place, which was interesting. We're finding a lot of Latinx people now, but back in the dates we were looking at for District Attorney Paul Fink's 1995 to 2003, we didn't have a lot of Latinx people in that population. Now we're seeing them as we're doing more data on this current DA. So it's just interesting on how the system evolves and keeps evolving to just harm other people over and over. And so we held them accountable. We didn't realize so many people would come. It was about 100 people. And their argument was it wasn't us, it was Paul Finks. Each of them worked there when Paul Finks was district attorney. Some of them were the actual prosecutors in the cases, but it's not their fault. It's Paul Finks's fault. And so we're challenging that. And KPBS came in and that's why I can say the media and the importance of the media. A lot of times I don't like the media, but KPBS told me that it's not always bad, showed me that it's not always bad. They did a two-part investigative report and they went and looked at the data themselves. And they were astonished that so many young Black men, 18 through 25, that's your youth offenders, your young adult offenders, some of them non-killers, some of them killers, were basically told that they will never come home. But yet their counterparts, similarly situated, young white men, were basically told, about 90% of them, that they will. So the data is flipped, about 90-90. 90% of young white men will be able to come home. 90% of young Black men were thrown away as non-redeemable and non-rehabilitative. So now, in the spirit of Martin Luther King, we laid out the facts. Our negotiation was the tribunal. We're a Muslim organization. We just finished Ramadan, so now it's time for direct action. And that's what we're building towards in challenging a disparate sentence and alley-ooping anything that we can do on the streets as organizers to these impressive attorneys that are fighting tooth and nail against a messed up system.
Thank you, Layla. And I think, yeah, the community tribunal, you know, it's related to the RJ, but it's a separate way to go after the people who have, you know, not only blood on their hands, but the blood of people we know on their hands, which makes it, you know, for many of us is very personal. And I know it does, you know, for the advocates as well. But yeah, I want to, you know, thank you and Pillars for kind of putting this together. I know there's some historical examples that you cited in the past, but I think it gets to the heart of what RJA, you know, the secondary purpose of RJA that we at Debug and in participatory defense feel, which is it's a way to engage in a larger system critique. And it's a tool to get people home, but then also to engage in that critique. So on the theme of alley-ooping it to the public defenders, we have Brett Hammond, like I said, who is here. And our relationship personally, and I know it's the same with Layla down in San Diego, but it's been, I think, one of the major things that moves us to create a website. Is that we're tapped into what's coming in terms of on the calendar, and how we can be there and fill the court. You know, for folks who have RJA claims, but oftentimes don't have a dozen family members, like we become with some of the folks who are creating these claims. So Brett, I guess to kind of take us back, we're kind of in all the passion right now, but can you talk about, like, procedurally, what's your process when you kind of hear of a potential RJA violation? And then can you just talk about what's the process like from hearing, you know, somebody got arrested and it was a pretextual stop all the way to, like the office has, winning an RJA motion? Can you talk about that process?
For sure, and thank you for having me, Zach. Having community members and Debug support what we do in court has been absolutely instrumental. So when we first show up to court and meet our clients at arraignment, all we have are the police report and a rap sheet in front of us. And the police never tell on themselves that explicitly. So there's never going to be an exhibition of bias that's super explicit in the police report. So one of the first places we go is talking to our clients. And my predecessor, Karina Alvarez, who's a fantastic attorney, developed an arraignment sheet that a lot of our attorneys use when they first meet our clients to ask them, what was this like for you? You know, being pulled over by the police. Did anything happen that felt weird? Were there any comments about your clothing or your music or anything that made you uncomfortable? Just to get that conversation going. And sometimes our clients are very eager to tell us about those things. And sometimes they assume that it's not relevant because they've been through this before and they've been told it's not relevant before. A lot of times the attention quickly goes to, yeah, it sounds like it was really unpleasant, but let's talk about the facts that matter, you know, guilt versus innocence. And that's what makes the RJA so revolutionary, is now that experience that so many of our clients go through does matter, because now it is actionable and there can be real remedies for exhibitions of bias that happen on the street, right? So we talk to our clients first. What happened? And one of the recurring issues, and Zach, you mentioned this, that there probably needs to be more implicit bias training for attorneys. You know, we all have blind spots. I have a lot of blind spots personally. So when I'm going through a police report or I'm watching body worn camera video, there are things that feel off to me, but I don't know exactly why. So part of our success in the public defender's office, I think, is talking with other members of the community, going down the hallway in our own office to talk to other people, working with experts, and talking to our clients about what did this mean when the officer did this. And our clients are oftentimes the most helpful on that because they are members of the community that that same officer might have been hassling for some time. So they can explain what some of the lingo means to someone like me who doesn't know, right? Once we get a sense that something is off and needs to be explored, like I said, it's usually not going to be in the police report. We need to watch body worn camera. That's where it is. And it's not just the first 5 minutes, it's the second hour sometimes of the body worn camera when the officers will say things to each other and under their breath that kind of reveals their racism and their true motives. They'll say stuff to each other like, I knew we'd find something in that guy's car. I knew it from the beginning, the way he was doing this and doing that, and they'll start using racially biased language with each other. And that gives rise to our claims. And we work with experts a lot from the community and from local schools. I mean, this is we're going to Stanford and Santa Clara University and Berkeley and Harvard to get experts in critical race theory to explain to judges and DAs who don't know how kind of the dog whistle racism works, the coded racism works, explain in a very scientific way. This is a real science and this is a real phenomenon. Because otherwise, without that weight, sometimes it feels like we get gaslit a little bit. We see something and our clients see it and they tell us about it, and we're in court saying what the cop said, even though he didn't use an epithet, what this cop said is an exhibition of racial bias. And the bench, who's largely older and less diverse, looks at us like, you're crazy, you're seeing things that aren't there. So to have community members, to have experts come in with fancy degrees and everything really helps convince the judge that this is real. But it's not just experts with fancy degrees, it's community experts as well. And you and Raj connected me recently in one example to a local high school counselor. And he was able to tell in a declaration to the judge, and this will be my last point, about how one of our clients' distinctive haircuts really was distinctive to his racial identity. Because the judge doesn't know that this type of haircut is really a proxy for our client's race. And there's not going to be probably like a Harvard PhD that can say in San Jose, members of the Latinx community have this type of haircut predominantly, but a local school counselor can. And he can say, I've worked with thousands of teenagers and I can tell you, I know exactly what haircut you're talking about. I see it all the time. And I pretty much only see it on young Latinx people. And he's an expert. He's an expert in that area because the standard to be an expert is not super high. You don't need a fancy degree. You just need some specialized knowledge that can be helpful to the trier of fact. And in this case, it's a judge. So that's an example of how a community expert that I'm thankful to Debug for connecting me to was able to really drive the point home with our judge that this comment that was made about our client's haircut really was an exhibition of racial bias.
Thanks, Brett. And I think, yeah, you got to kind of both parts of the expertise. And I think one of the things we've realized as an organization is that like many of us have expertise that is kind of within us. The only kind of training that's needed if you're ever going to go in front of a court is just to understand how to answer questions. And so that's one of the things that we've been trying to do as an organization is identify folks. Maybe it's a barber, maybe it's a person who works on cars locally who can talk about why people like these types of cars and how they're not associated with criminality. And I think a lot of what community experts do specifically is that conflation of ethnic, cultural, racial, familial attributes as inherently criminal and as grounds for reasonable suspicion or probable cause. That's one of the things that I think the Santa Clara County Public Defender's Office has a handle on this pretrial, and it's been really fun. We'll hear from Xavier in a second, watching you all advocate, even though it's it's not always winning, but it's a fight. And I if there's an expert, I've seen this from Santa Clara County Public Defender. If there's an expert on the entire earth that could speak the best to this person's condition or to the racial bias, they'll find them. If they're in Europe, as we've seen, And we also, as you know, as a person in court, and Xavier can talk about this, it's amazing to hear about some of these communities that are amongst us, um, who are so oppressed and alienated, and to have these experts come in and be able to kind of redeem these people's culture when a lot of times police procedure and police best practices say that their culture is, you know, evidence of criminality and reasons that they should get searched. It's amazing to hear those people with the nice fancy PhDs and the doctorates, but also knowing that there are people among us who can do that. But yeah, thanks, Brett. I might have more on the community expert stuff later, but I'm want to switch to Xavier, who is one of our, I guess, our community experts in waiting. He has a lot of personal experience, both with the system, but like I said, being in court during these RJA hearings. So I guess Xavier, if you could you talk to us about kind of from a participatory defense lens, how are you supporting people when they come in at this red table that's home base for us? What are you looking for? And what's your procedure when you have just a family who comes in and say, you know, something feels wrong. I have, you know, I can't point to it like what Brett was saying, but something feels wrong. What's that process of guiding the family through through looking at this like through a pretrial and also post conviction lens?
Yeah. So at Silicon Valley Debug, we've had families come into our meetings even before RJA. So just the experience and the familiarity that we have with the policing around here locally. We're very familiar with the kind of, I guess, the profiling that's common here, right? So when we see cases that initially there might not be a RJA claim, we like consider like, hey, is this something that would have happened to somebody that, you know, wasn't Hispanic or wasn't another minority or whatever. We kind of review it in that lens as well. So we've had an individual come where the case was a pretextual stop, but led to, you know, searching of the car, pulling the individual out. And to us, we're very familiar with the tactics that is done with SAPD. So we kind of flagged it. We put together our notes. We put together the lens with the individual, with other folks from Debug. We connected with the public defender's office, and as Brett mentioned earlier, you know, sometimes we all have different lenses. Sometimes we have different blind spots, and together we're able to work to kind of build that RJA claim. And it's more common. Well, right now with the way the implementation is working for pretrial, but also post conviction as well. We've had folks who are coming back for resentencing, or there's many different avenues that are being implemented for types of relief for people that are post conviction, right? But then we also don't just focus on that one particular avenue. We also look at it like, hey, is there a RJA claim in this case as well, even though it's not pretrial? It's a little bit more difficult because we're not looking at it directly, right? We're just looking at transcripts. You can't really gauge of like maybe a tone, a look, a certain smirk in a transcript, right? Because that's not recorded. All you have is words, and sometimes those words are kind of not accurate as well. But there was a case where, you know, the alternative defender's office was looking at, and we were already supporting the family on a different avenue. We looked at the transcripts in the RJA lens, and then we kind of shared our notes with that attorney. And, you know, it led to a meeting. We're like, okay, let's talk about this. Let's see if we could, you know, trade ideas back and forth. And it seemed to kind of help push that case a little bit forward with the RJA, because that attorney was also just looking at transcripts as well. But we know the policing, like their tactics here and locally, right? We know certain orgs or communities that are maybe more targeted by the police and stuff like that. So it was very helpful not only for us but also for the attorneys as well, which, you know, helped kind of like, you know, forward that case in the RJA fact. So yeah, I mean, that's kind of how we're supporting with folks in the RJA. And then well, I don't know, what was the other question?
I guess I have a quick one. I talked about a little bit about how you are the one who handles our mail. Could you just talk like super generally, but also briefly if you want to, just about what are the concerns that those folks are having where they're reaching out to us? I know Brooke mentioned a lot of them, which is, these are really tough claims. There's really tough procedural barriers. I need an attorney. But could you speak to that, whether there's folks asking about, getting an appointment of counsel or if there's anything else?
Yeah, definitely. One of the common requests is either the data itself on what's similarly situated to either their charges, their conviction, the amount of time that they got sentenced to. Um, because the stories that tell, they say I was the only black person in a big co-defendant case, and I'm the only one that had a severe sentence. Or it could be they had a lesser role, but they're still getting sentenced to more time or more charges. So a lot of it is data. Like I want the data that's similar situated, so I could show, the disparity that I'm getting just for, the color of my skin, my, where I'm from, or how I dress, and this is what was used against me. And then another one definitely is appointment of counsel. Like, hey, I want to get this RJA claim started, right? I want to know how I get that process started. Can you help me with filing it? How do I file? Are you guys attorneys? Can you direct me to an attorney because I have this case, I have this claim, they have the story. If I could get the data, I could prove it. Because it is a lot more difficult for folks without an attorney to request data. From what we've seen with pretrial, um, district attorneys are also they're opposing and fighting data even with cases that are in present day. So to us is like, okay, I mean, at least to me, in my opinion, is like if there's RJA claims being passed today, then there's definitely got to be more RJA claims that happened in the past, right? Are we saying that there's more racism today than there is in the past? I don't think so. So definitely asking data, appointment of counsel, and also just like how the RJA works, really. Like how could I use RJA for my case? Um, like the case that I mentioned earlier, when we reached out to that individual that was inside and explained what RJA is, what the fact that it has racial in it, to them, they're so numb to being the target of racism that it's the level of racism that they are thinking is a lot higher than what the bar is for the Racial Justice Act, right? And they think it's extremely just like, oh, they didn't say a derogatory term to me or anything like that, but that's not necessarily the case. It could be just some type of bias, of saying maybe comparing them to an animal or something like that, or and also it doesn't just apply to they think that it just applies to a district attorney or in the actual trial phase, but it could apply to any part of the whole, like from the arrest to the police officers. It could apply to experts, to a district attorney, to a judge, to a juror member. So it could be any player in that whole justice process that could get a RJA claim filed on them, right? Because we've seen that there is stereotypical and racial disparities on different parts of the process. So um, those are like common things that are being asked from folks inside, and hopefully with the new, I mean with the website, it could kind of help share some of that insight that we have, that folks that really need either that are currently writing their own habeas or seeking counsel, and can compare it like, oh, if this is what happened in this case, then then I definitely have a RJA claim in mind, right? So yeah, that's kind of what the common ask is in the mail from people inside.
Right. Yeah. Thanks, Xavier, for that. I know we had some participation in the chat regarding a question about derogatory language with gang members, and I also think like the and how it affects jury issues. I think this is a really interesting question. I'm kind of as the moderator, I'm happy to also broaden it, which is talking. I don't know if someone wants to talk about how I think it's recognized now that gang uh, quote unquote gang evidence is like the most unduly and highly prejudicial thing that you can put in as evidence. And of course, we know from kind of like the the percentage of people, which I think is over 97%, Black and brown people, are the ones who suffer under the oppressive gang enhancement regime. So I don't know if anyone wants to talk about some of the specific things they'd be looking for in a gang enhancement case when it comes to RJ. Of course, I think animal language is something that Xavier just mentioned. But I don't know, Brooke or Brett or Layla, if you have any thoughts about maybe the specific ways that RJA can intervene when it comes to these gang enhancement, so-called gang cases.
I mean, I don't have a ton to add, but I'll say that it's definitely a phenomenon that we see all the time, that officers will use signs that are really innocuous and could just be part of someone's culture as indicia that they're in a gang. You know, if someone appears to be Latino, the officer will use that person's nickname. It's just an innocent nickname, and that nickname becomes a gang moniker. Or if someone is wearing, I just was reading a police report this morning about an officer who says, you're wearing a red Astros hat, that must mean that you're in a gang. And they ask the person, are you a big Astros fan? Can you name any Astros players, to try to test whether he's really an Astros fan or it's gang indicia. And we know they wouldn't ask someone that looked like me if, can you name the players on the team of the shirt that you're wearing? So we know it's racially biased, and it's just a matter of proving it in court and leveraging experts to explain all this.
Definitely. And I think there's, sorry, go ahead.
No, I was just going to add it. I also think there's, I think this is an opportunity to use, I'm a big fan of our public library systems, but to go in and to there's a lot of research out there about gang pilot programs that different law enforcement agencies have created and the problems that they had. It's also understanding a little bit more of how your particular county tracks gangs, right? There's a number of large police associations that had, their gang cards, right, that they would fill out on the street. But understanding how they label people, how they have historically done that, how it was based on a little bit like Brett was saying, of just that they had a color and they were in a neighborhood. And now I have 3, and so they go into my database system as a gang member. Getting the court to understand that these actually are not sophisticated systems that they are using to validate people. We see the same with folks inside CDCR. It's also really problematic. And so getting the court to really understand that there are bigger issues when we decide who is not a gang member. And I think this is another point where community folks coming in and dispelling a lot of what our gang experts testify to, right, of how did local politics actually play out? How are those relationships, et cetera? And I think when it comes to jury selection, it is complicated, as one person mentioned in the comment, is gang is often attached to a specific charge, and so then it's already in the vernacular, and so it becomes problematic from the start. But what I think we need to start doing is really expressing that we use the word gang for Black and brown groups of people that associate with each other in a way that we don't if you see a group of white folks on the same corner in front of 7-Eleven every Friday. Like, they're not called a gang, but it's the same group of people doing the same thing, and really getting the courts to understand that difference of how do we categorize groups of people, and in the community, how is that actually experienced, and how different that is from how it's perceived by law enforcement.
Yeah, I think that's amazing. And I think also the conflation of people's neighborhoods with criminality, as if people had any control of where they come from. But I think it shows how it's just nakedly racist. Jamila put something really, really powerful in the chat that I saw. Calling someone a gang member is like a racially coded way to associate Black and brown people with violence, which exposes the jury with to kind of selection with racial bias. And it also opens them up, in the mind to extraordinary state violence, which is what gang enhancements are, which is what our gang specials are. And we know, like I said, and like you said, Brooke, these only go after certain types of people from certain neighborhoods. And so I think it's one of the hardest things that we'll have to do is to show the court that, yeah, actually the statute you're charging on is very racist. So to kind of get into the multiple levels of racism, given it's on the books, I think is a tough task for all of us to kind of get over. One thing I wanted to say for people who are looking at kind of how to argue this neighborhood racism, Joseph Doyle, very, very good attorney, People v. Howard has a case where he discusses how the conflation of Mr. Howard's, association with the neighborhood and with the town that, we at Debug are, we hold dear. It is used throughout the case to fill in the gap of reasonable doubt and to play on the fears and the racial bias of jurors that they might not even know exists within them. So just if we're doing a reading list, which I know Layla was, and Brooke was nice enough to direct us towards some stuff, I'd say that's a really good way to see how the possibilities of how things that we know as kind of community can be turned into really strong appellate briefs, talking about how the burden is being met oftentimes by a pretty naked implicit bias, and I guess very, very naked explicit bias. I wanted to get back to you, Brooke, because I know that there are many folks we have who are incarcerated and everything's very, very slow. What are the things that we can look forward to, or maybe down the pipeline, they're not sure. One thing I was thinking of was AB 1071. But also, does OSPD have some type of resources that they feel comfortable sharing or talking about that might be coming down the pipeline?
Yes. So some folks inside have received like our standard letter that just kind of explains some of the things you can do to start preparing claims. But we will be releasing kind of more comprehensive pro-per packet in the next month. This will include Macintosh, the case I was talking about earlier, to make sure the trial court has the case law in front of them. It will be very clear that people are requesting a lawyer and disclosure. They're not requesting an actual hearing just yet. And this will be kind of a fill in the blanks in some ways. And what we are basing this off of is we've been collecting pro-per filings from across the state to see who's having success and who's not, which is, as many of you know, depends on the court you file in and the day of the week and who else knows. But trying to get some trends going that we can then explain to people. And I think that what people can be doing in the meantime, I know there's often a concern about timeliness, right? People are worried they're going to lose their window. And I just want to stress that when it comes to the RJA, there's so much up in the air. AB 1071 is a huge piece of legislation we're working on, for example. I think timeliness on the lawyer side, we are less worried about than with other legislation that comes down the pipeline, just because it is so complicated. And so when it comes to timeliness, what you want to be tracking is what are you doing in the meantime? So making requests to your DA or to your making public records requests, et cetera. Those all extend your timeline if you can show you're diligently working. And so this is a really great time to think about, as Layla and folks were saying, our judges are really out of touch, but particularly in retroactive cases, gentrification has happened so rapidly in so many areas that what a judge thinks of for a particular neighborhood is going to be totally different. And to start building that context of what were the neighborhoods, what were the politics, who were the players, what was the language being used in the area, what was policing like, but to tell these full picture stories. I always caution people, there's a lot of focus on data because pre-trial, we have a lot of data now, but particularly pre-2010 and a lot of counties even now, there isn't data. And so don't exclusively focus on that. We want to be telling a more comprehensive picture of the discrimination that we were seeing, of like, here were the state trends, the national trends. This is the narrative in the politics, looking at political campaigns, what things people were running on, to really give an idea to the court of like, this was the height of the super predator era, and then I came in as a young Black man. This is the environment I was walking into. And so we're going to be trying to walk people through some more how to build out this context.
Great. I know we'll be looking kind of forward to that, and we'll be sure to blast it out once it's public. And you know, for people out there who are praying, definitely pray for our AB 1071 bill that we're pushing. We hope that it will stop some of these procedural barriers. As Layla said, let's get to the meat and potatoes. Let's talk about the actual racial bias. It's frustrating, especially for us, that we can't even get there with a lot of these cases because we're so stuck, especially with these retroactive cases. I guess, Brett, quickly, could I ask you about, I know you're the deputy public defender kind of in that RJA seat right now. For folks who are in other counties, could you talk about like what does it look like? Do some counties have that that RJA attorney like you? And does that depend on like whether they're kind of a bigger county or a smaller county?
I think it depends on the size of the county. Yeah, we're lucky to have the resources that I can full-time be dedicated to pre-conviction RJA claims. I have a very talented coworker, Jory Zalona, who's full-time dedicated to post-conviction RJA cases. I've heard from other offices that I think San Francisco has more than two, but I also know that some smaller offices don't have anybody who's fully dedicated to RJA. So it's more of a competence that all the attorneys need to know. And in our office, we want every attorney to know how to do it, and we want to have the folks who are full-time on it be able to assist them. But it can't be the case that, you know, there's only one person in the office that knows how to run an RJA claim. So everyone needs to know how the RJA works, but also be trained, like you mentioned at the top, in recognizing implicit biases. Because if an individual trial lawyer has a case and isn't seeing the thing that is messed up, then and maybe if that client isn't going to be super vocal about it, then nothing will happen. You know, so we need to be vigilant and looking out for it.
Thanks, Brett. Yeah, so like, you know, we have here, I encourage folks who are in other counties to connect with their public defender and to get into that implementation work. I know our time here is winding down, and I know I'm tasked with giving some kind of forceful conclusion. But Layla, I think you, to me, kind of embody what the spirit of this thing is, and also kind of the long suffering and the work that is to come. So if you want to give us kind of a message about the RJ in terms of where you think it's going, you know, from your perspective and what you see in court, and how we can, I guess, as Dr. King said, bend the arc of justice.
I think because people have been working together, attorneys, organizers, families, that we are going to change and have a good ruling on the disparities. I don't think it's going to come from San Diego, or I don't even think it's going to come from our appellate district. I think it's going to come somewhere else, or the California Supreme Court. I don't know. Our Court of Appeals is doing a little better. I want to thank the attorneys that are really pushing this. I've seen some incredible things even now come out of RJA that we didn't expect. Like, say, for instance, we talked about SB 1437. We just court watched a motion where the judge was taken. He was excluded, the trial judge. In 1437, they make you use that trial judge, and there's nothing else you can do about it. Well, RJA made the trial judge by law have to basically get rid of the case. I know there's a great legal word for that. Maybe Brooke or Brett can help me with, but yes, basically, so we are seeing things on the ground that are good for strategy. We have to keep doing those. We have to keep fighting those battles, but I do believe that not only are we going to get some relief, but it may change the way business is done, but we're not going to, we need other things such as the bill you guys are running now. We need cleanup bills. We need different kind of rules and policies within the court system. And then, of course, case law coming out of the courts. So the fight is just beginning. And I want to thank all of the freedom fighters who've been a part of this.
Yeah, and I want to echo Layla's call. We have tens of thousands of folks down who we know racial bias, you know, and also the systemic bias that you know redline people into these neighborhoods, that brought them into police contact, that brought them into, you know, to be associated, to have their associations criminalized, all the way to that LWOP sentence. That, you know, we have folks who are, you know, systemic victims inside, and we need to do our best to help them. I can't do any better than Layla did right there, but I can just conclude by just saying that we, you know, thank everyone for coming. We'll drop some of our links below in terms of the website, RJ Action. Andrew would love me to say, please sign up for that little email pop-up thing that comes up, and you'll get the updates whenever they come out. And also to the folks on, if you're in a county, if you're not connected with us yet, we would love to be connected in terms of ways that you've been in, seen RJA work, not work. We would love to hear it. And we would love to kind of have new contributors who aren't some of our common people who go and court watch. I know that we have some from San Francisco. We have a story from San Diego, and we hope to expand that. As always, we're kind of guided by participatory defense. That's what you see in the background here. That's our model. And if you're in a county in California and are trying to figure out what's going on, especially some of our smaller counties, reach out to us and we'll find you a home where we can try to work on the case with your guidance, you know, led by the person who's incarcerated or is facing these charges. And we'll do our best to kind of push the ball up the hill like all the people on the panel have. So I want to thank everyone. Brett, once again, from the Deputy Public Defender, Santa Clara County Public Defender's Office. Layla, amazing organizer from Pillars of the Community. Brooke from our lovely OSPD, who has some materials coming from us, and colleague Xavier, I want to thank you. And thanks everyone who took their lunch hour to join this. And, you know, the fight's going to continue, and we'll do it for our people inside and the people out here. Thank you.